There are two basic ways in which a married couple can agree or have the court agree on their behalf the terms of their separation if they decide if the relationship breaks down and they decide to live apart. One is a judicial separation. Now there's two ways to do that. Either the parties can agree on the advice of their solicitors and draw up a separation agreement, they both sign it, and then they're bound by the terms of that separation agreement. On the other hand, if they can't agree terms, etc., and they have to go to court and the judge decide, the judge will make a ruling on the matter and they will have to adhere to that ruling. Now, the interesting thing is that when parties draw up a separation agreement, unless they're being advised by a very, very foolish solicitor, or two very foolish solicitors, one on each side, then the succession rights to the estate will be dealt with in the separation agreement. And if the matter goes to court, has to go to court, and the judge is making a ruling, he or she will certainly deal with what happens in the event of somebody dying and what the succession rights, if any, of the other are. Now, of course, the other way in which people can separate and live apart legally is by getting a divorce. Now, if you get a divorce in Ireland, the divorced party has neither party has absolutely any automatic rights to succeed the other party, to succeed to the other party's estate. There is one exception, however. If the person who died, if the survivor isn't catered for, either in the will, if the survivor is not catered for in the will, and they can then apply. They have the option actually of applying to court for a share of the estate if they feel they've been badly done down, or if they feel that they were so financially dependent on the person who died that they should have at least got something. Every case is different, and every case depends on its own facts, and it's entirely up to the judge to decide whether or not the person is entitled to a part of the estate. Before a person brings such an action, my advice to them would be to get very careful legal advice on what their possibilities of success are. Now, as I've said, if a couple who are married decide to live apart, let's say that they're married and they just stay together for a year, and 40 years later one of them dies and there's no separation agreement or no divorce agreement in place, or no prenuptial contract in place, a legal written agreement in place, then the other party after 40 years can come back and claim to be the spouse of the person who died and have all the rights of a spouse under Irish succession law, which are very considerable. I mentioned in my last YouTube video that if a person dies and they don't provide for one or more of their children, or at least don't provide for them adequately, that child has a right to go to the High Court to seek a part of the estate. Again, every case depends on its own facts, and the judge will have to decide whether, in all the circumstances of the case, taking everything into account, such as, for example, the child's own status in life, how well off they are themselves, how well off their parent was, whether the parent made provision for them or gave them money or property, etc., during his or her lifetime. Everything like that will be taken into account. Actually, the wording of the Act is that the person will be, the court will make an order in favour of the person, in favour of the excluded child, to a share of the estate if, and I quote, the person who died failed in his or her moral duty to make proper provision for the child in accordance with his or her means, unquote. People often ask about cohabitees, people who live together. If two parties get together and live together, and they don't have any written agreement in place as to who will inherit what when one of them dies, then if one of them dies, the person who survives has absolutely no automatic rights to succession at all. Now, if the person who survives was financially dependent to a large extent on the person who died, they can bring a case to court, again, looking for part of the estate on the basis that they haven't been properly provided for. But in order to do that, they must, if they have kids together, they must have been together in a proper marital type relationship for at least 2 years in order to enable that type of case to be brought. If they have kids, then they must prove that they were living together in a marital type relationship for at least 5 years to enable that type of action, that type of case to be brought. Um, People often ask me about a situation where somebody dies and makes a will, and the executor then has to take out probate, which means, distributing the estate, paying off the bills, and paying people who are entitled under the will to what they're entitled. They ask me about what about paying funeral expenses, etc. If the estate includes money, cash in a bank or credit union. Well, the general rule is that when the person dies, their estate is just frozen, and the executor has to has to take out probate before before the executor can distribute the estate. But there are a number of exceptions. If the bank sometimes, for necessities, can decide, the bank where the money is held can decide to pay out a certain limited amount. For example, the bank can decide to allow the executor to draw out money to pay funeral expenses. If the estate includes the proceeds of a life insurance policy, the insurance company can decide to pay out the beneficiary. However, if the two people who are living together have any property in common, in other words, if they have joint ownership of any part of their property, then the surviving party automatically inherits all that. So I'm just making those points today to illustrate that, because the law is so uncertain here, and states can finish up in court at considerable costs to all parties involved, because the money to pay the lawyers on both sides will have to come out of the estate. It's very important to make a will. Some Irish people have a natural disinclination to make wills. They feel that if they make a will, they're going to die shortly, which of course is nonsense. So my advice to people would be to consider making a will. It's not a very expensive process. If the will is simple and straightforward and you have a limited estate, you can get the form in certain shops in any city or town and do out the will. All you need is 2 witnesses and somebody willing to act as executor. So that is very important. There are uncertainties around inheritance in Ireland, particularly in relation to cohabitees and people who die without a will. So it's very important and relatively inexpensive to make a will. And making a will does not mean that your lifespan is shortened in any way, shape or form.